This is The Law Show on CL 650. Now back to the show.
And welcome back. Yeah, we're talking about estate law. We have John Lakes and John White joining us from LakesWhyteLLP in North Vancouver, and right across from Capilano Mall. Lots of parking, I found that out, and it's free. So we're talking about gifts, and that is a gift, the free parking, by the way. But we're talking about estates and gifts to people who have been, what would you call them, beneficiaries or noted in the will?
Yeah, beneficiaries.
Just beneficiaries. So we have a couple of interesting stories here to highlight how things can go wrong. One is a story from the 1920s called the Stork Derby. So give us a little bit of background on this and what happened.
Well, the Great Stork Derby, as it's called, is sort of the, I would say, intended consequences of a guy who was a lawyer in Toronto named Charles Vance Miller. He died in the 20s. And he was a bit of a practical joker, and so he wrote it up in his will that he was going to give a significant, basically the residue of his estate, and it was a lot of money, to the woman in Toronto who could produce the most children in the decade following his death, which then set off a little bit of a population explosion in Toronto. There were 11 families that found themselves effectively competing for this legacy, and a bunch of them.
Was it enough money to look after all of these children?
Well, apparently,
maybe back in the 1920s.
Back in the day, it was. I mean, there was litigation, as you might expect, arising out of such an unusual scheme as this. 7 of the families were disqualified, but there was a ruling in favor of the other 4. Each of which family receives $125,000, and collectively they produced 9 children, and that was a lot of money back then.
Yeah.
But could you do that today? It certainly.
So it was upheld.
It was upheld. Yeah.
Yeah.
I mean, the court did what it usually does in these circumstances. It did its best to derive some intention from this crazy will that was put before it.
Do you think this was just a lawyer's idea of making more work for lawyers?
Yeah, it could have been. I mean, it certainly would have done that.
Mm-hmm. It's interesting. All right, now what about this Spence case? This is a little bit more serious, this one. The Stork case is fun. Mm-hmm. So what's that one about?
Well, this is Spence and BMO Trust. This is a case that was just decided last week by the Ontario Court of Appeal, which and Ontario, I think, is different legislation than we do, because I don't think you would see this happening in British Columbia. But Mr. Spence, the testator, was apparently kind of an Archie Bunker kind of character. And he basically was heard to exclaim many times in his lifetime that he wouldn't leave any money to his daughter, and in fact effectively disowned his daughter because she had a child, and the father was white, the daughter was black. Mm-hmm. And a court in Ontario, a lower court in Ontario, found that basically he had disinherited his daughter because he objected to the race of her husband. And the court said, we're not going to uphold that. That's simply offensive in this day and age for anybody to do that. Went to appeal. The Court of Appeal didn't disagree that that's highly offensive, but said, you know what, it's a will, and in Ontario at least, it upheld the principle of testamentary autonomy and said, basically the will maker is entitled, says the Court of Appeal, to be racist and offensive.
So it's racist and offensive, but that is his will.
But that was his will, and the court upheld it. It's now going to the Supreme Court of Canada, we learned. That was the news on this. I don't think this would work in British Columbia.
Because we have a different system.
Well,
right?
What we have is, and we'll talk about this in another show, is wills variation legislation, where somebody with standing, like the daughter of the will maker, who was cut out on such a ridiculous basis as Ms. Spence was, would simply have rights under the Wills Variation Act to apply to the court to vary the will, and I have no doubt at all that the court would vary the will in these circumstances.
Interesting. All right, now we want to get into the cash again, because at the end of the day, a lot of arguments come around with families because of cash. So But you have this tricky situation where you have a will maybe that's been written years before and hasn't been updated, and things have changed. For example, you state in the will that my gold watch is going to go to my son, but the gold watch has been sold, right? So what happens in a situation like that?
Well, we have a concept called ademption, which is one of these weird words that really doesn't come up anywhere else that I can think of except in wills cases. But it basically, the gift fails if the subject of the gift doesn't exist anymore. And the word we use is that it adeems. Basically, there's an intestacy with respect to, well, I guess if there isn't an intestacy with respect to that gift, the gift just doesn't happen because the subject of the gift isn't there anymore.
Unless, so you could always have an example where you could say it's been replaced. So, for example, let's say in your will you leave your one-bedroom condo at Whistler. Well, at the time you've died, you've sold your one-bedroom condo and replaced it with a two-bedroom condo. It could be argued that the two-bedroom condo is a replacement for the one-bedroom condo, but it might have to go to court to resolve that issue, which is why people got to update wills from time to time. But
So let me just give an example. So you say, I leave my condo in Whistler to my daughter, but the will was written before the second condo was purchased. So could that be argued?
No, what I meant was if you said, I leave my condo, whatever condo you have is, but if you specifically say, I leave my one-bedroom condo at 1-2 Spruce Drive to my daughter, but at the time you've died, you now have you've sold that one, but still have a condo at 1-2 Spruce Drive, but it's a two-bedroom condo.
Right.
There could be an argument that that gift does survive because it's just replacing one gift with the other, but it's why, again, the problem you have is the most important person is dead.
Right.
They're not there to give evidence. We won't accept Ouija evidence, and that's where John may, depending on who John's acting for, if he's acting for the other siblings, they say, of course, the daughter doesn't get it. But if he's acting for the daughter, he says, yes, she should get it. So, and there'll never be perfect evidence.
Can you jump in on that?
Yeah, well, no, true enough. I mean, it does, of course, depend on the perspectives of the beneficiaries, and it's amazing how much people's perspectives change depending on whether or not they're going to be awarded a large sum of money in somebody else's will. But yes, I mean, there is room for argument in many of these concepts that we're talking about, and the court is always going to be interested in trying to figure out what on earth the testator actually meant, because we're only there in court if the will maker used the word testator, but the will maker is perhaps more up-to-date language for the same person. The guy, the man or woman who's making the will. If they'd been clearer at the time, there wouldn't be scope for an argument. We're talking about situations where, for one reason or another, their intentions are no longer clear, and the court will always try and figure out what the intentions of the will maker were, to the extent that that's possible.
Does that just come down to common sense at the end of the day?
There's a lot of common sense in this. I mean, it's people like to say that there isn't much common sense in the law, but there really is. The law really evolved out of an attempt in large measure to codify common sense, and wills and estates law, however complicated and convoluted it appears to be, at the end of the day, common sense is a big part of it.
Okay, let's get into, I say in my will I give $50,000 each to my three grandchildren. At the end of the will, there's only $50,000 left. So you've got more gifts than you actually have money.
Yeah, well, the problem you have is if you've given away too much, then generally you have to go back to the will and maybe argue that, let's say you've given away $500,000 and you only have $250,000 left, people may have to accept half of what their gift is. But it depends on the will, and there may be some priorities too. So there could be an argument that Mary's 10,000 ranks ahead of everybody else's too. So it may be subject to review by the courts. It may be subject to litigation, and it's why people need to make it really clear too. There's another thing that people have to worry about, and you raise the issue of old wills. If you've got a gift to something that doesn't exist anymore. So, for example, until 15 years ago, there used to be an elementary school in North Vancouver called Lonsdale Elementary. Now, if you have a will that says we leave $10,000 to Lonsdale Elementary for playground equipment, and of course the school doesn't exist anymore, there's an idea of whether is that still a charitable intent, where you could argue that yes, that $10,000 gift is good, but now it goes to North Vancouver School Board, or whether that was a specific gift only to the Lonsdale Elementary, and since it doesn't exist anymore, it falls into what's called the residue.
All right, and we're going to pick up on the residue when we come back. What happens to the money that's left over after all the gifts have been paid out? We're talking estate law with the two Johns here, John Lakes and John White from LakesWhyteLLP in North Vancouver, and we'll pick it up next on The Law Show on CL 650.
There's more of the show still ahead. This is The Law Show on CL 650.